about then the advocacy skills. So I'll dive straight into it. I have about an hour, so we'll try to finish it by 3:30. So I plan to do it about 20 minutes to 25 minutes on the half an hour on the presentation. Uske baad we can do a bit of questions and answers. हमारे पास mic है to go around. So मुझे वासी साहब ने बताया कि all of you are getting ready for your interviews and you've been in the course for about 6 months or so. So I thought कि these advocacy skills may be a relevant topic for me to talk about. So next slide. Advocacy is about presenting your case. Simple, straightforward thing. The reason I titled it Advocacy and Practice Skills is because there is a slight difference between the two. Advocacy is what you actually do in a case, and practice is the broader context in which you operate. So how you run your office or your firm, what values you adhere to, and we'll talk briefly about it. So practice skills is a broader set, it is the bigger picture. It is learning to know your style. Where on the spectrum are you? So you can be a pro-settlement or a very pro-trial lawyer. You can be an amiable, cooperative professional where you like to cooperate with everyone, or you can be very aggressively competitive. And you will find these flavors across different practitioners. You can be a team player or you can be a solo sumo wrestler. You don't want to be a part of a team. You can be very scholarly or you can be very street smart. You're not interested in doing a lot of legal research, but you can be a good street smart advocate. And you can be a very self-driven person, your self-interests are supreme, or the societal interests can be supreme to you. These are extreme spectrums, the extreme ends of a spectrum, and you can be somewhere in the middle. What is important is that as a practitioner, when you start practicing, you do some self-reflection, and you ask yourself that where on the spectrum of these you fall, and a bit of self-awareness of what is your individual style will be very useful for you in your practice, not just the advocacy. There is room for, in fact there is need for various kinds of styles, but self-awareness is very important as to where you stand. Other questions you need to ask yourself is, do you respect your work? That is important. And practice hard work with dedication in a consistent manner or not? Are you only one of those who opens up the file only the day before? Or you are somebody who sets a regular schedule for you where you are going to practice and prepare over and over again? Do you value and uphold the code of conduct for lawyers? How many of you have read the code of conduct for lawyers, by the way? Raise your hands. Raise them high so I can see them. Now, why is the code of conduct important? Would anyone like to answer that question? Why is it an important document? All right, I leave it to you for anybody who wants to answer this at any time to let me know. I hope to get some answer before I go back. But I'm not going to give you this answer. You're going to give me this answer. Why is the code of conduct important? And why should you not pay heed to the common words you hear कि भाई ये चीजें मैटर नहीं करती हैं, यहाँ पे सब चलता है और यहाँ पे तो वही कामयाब है जो कि we can know how to cut corners. So ये Alim Saab, this is only about 5 or 6 of them have read, and in your examination you have to make sure you have at least in your interviews at least 1 or 2 questions on your code of conduct. It is a very important document.
मैंने लेक्चर को डिलीवर यही किया, पहला लेक्चर था और मैं क्वेश्चन भी करता हूँ इंटरव्यू के दौरान.
Okay. Is it important for you being an active member of the bar on the right side of the fence? Are you on the right side or are you on the wrong side? Is it important for you or not? Or are you only interested in just your practice? You come to the courts and do your work and you go back, or you do take an active interest in the bar, I won't say politics, but in the bar's activities. And why are these important? You would gather as you go along, because you're becoming part of an institution which has the highest traditions. And are you going to, we are on our way out after some time, and you are the ones who are going to come forward and carry this forward. So is it important for you that the institution that you belong to is an institution that can stand up with pride and say that it is held to the highest values of the bar? Then are you a solo practitioner, a firm, or a member of a chamber? This is also an important factor in what your practice is. So practice, basically, by the way, these slides will be uploaded on their website, and you will be able to download them. So later on, do think that why are these questions relevant? So one thing I can tell you, having been in the legal profession now for my 35th year, that cultivating wholesome practice skills as a general rule makes for a good advocate. If you see the most successful and the renowned advocates, barring very few exceptions, the reasons of which I will not go into, you will see that by and large, the best and the most successful advocates have been, who made the most money, who had the best clients, who had the best reputation, were the ones who stood for the best values of what we are talking about. In their private life, in their professional lives, in their bar lives, they stood for the right and they stood for the highest values. They didn't compromise. And in the short term, they may have lost, but in the medium term and the long term, they rose to the top. Think about those examples. So, advocacy is a subset, practice is a large set, and this is something that you need to keep in mind. Next slide, please. Nurturing. I put this image there for you to always remember that this is something that you will nurture over and over again, your entire life. In this profession, you are learning every day. Even after 35 years, I'm sitting there as a judge. Hardly any day passes when I don't encounter a new proposition that I have not heard of before, and I have not encountered before. So, learning is a lifelong experience. No one can complete the mastery of learning. And so, this image tells you that you would water it, you will grow, you will reap the fruits at the end, and then the cycle will start again. You can pick up a case. This is a learning exercise. Next slide, please. So, advocacy is written and oral. Today, traditionally it has been oral advocacy. When you go back in the past, somebody who speaks very well in the court and was considered. But today it has changed. Today, advocacy, both written and oral advocacy, is very important. Written comes first. and oral advocacy comes later. Very simple. Why? Because it is what you write eventually, not as much as what you say, will hold right up to the Supreme Court. This is what you wrote, this is how you wrote it. So, you need to pay a lot of attention to that. So, oral advocacy doesn't overcome deficiencies in written advocacy. What you call pleadings is effectively your written advocacy. So, you should focus on your focus on written advocacy always sharpens the mastery of your brief, and we'll talk about it a bit later. Find out your own strength. Is your stronger side written or your stronger side is oral? And then keep polishing your stronger side, but also consciously being aware, deliberately work to develop your weaker side. There are wealth of tutorials, presentations and courses now available online. When we started practice, nothing of this was there. And now you have such a huge wealth of these courses and training aids and presentations available on the website. It is only up to you how much time you want to devote on a per day or a per week basis to polish and learn these new skills. The wealth of materials is there. So you need to improve yourself and as a result improve the standards of the bar. And it's your practice which will make you perfect. Next. So look at these pictures. Does anyone want to say, what do these pictures reflect? Okay. They reflect a craft. You know what's a craft? What's a craft? Anyone wants to tell me what's a craft?
A unique skill.
The design.
A craft is a skill that produces a product. Right? So you can see there are craftsmen who are carving something, and it is a craft, and the product may be a beautiful output of that craft. So let's see the next pictures. So do you see a similarity between this set of pictures and the previous set of pictures? This is also a craft, and you need to practice those crafts. Think of yourself as an artist, and you need to start improving and perfecting the art form. You must have heard advocacy is an art. So that's what it means by an art. So there is no fixed method of craftsmanship. Every lawyer is unique, just like every artist is unique. Right? Just like every painter is unique. So every lawyer is unique. There is a huge blend of personality traits, professional traits, all of these that come together to make a lawyer. So don't worry too much about somebody else's skill set. Start working, recognizing and working on your own skill set. So next slide. So there are many tools, many methods, let's say, or aids or training aids for you to practice and improve your written advocacy. How to go about it. And one of those is what I call a 3-step process. So the step 1 is take the client's instructions, whatever he or she tells you, oral and documentary. When the client's instructions also include the documents that he or she shows you, think of it as a story. What the client wants and what he can really get are often out of sync. You know, so when the client comes to you, often the client's expectations are here, and what under the law you can get for the client is somewhere here. Right? So you as an officer of the court, according to the code of conduct, according to the highest traditions of the bar as an advocate, you have to write a story that will stand in court on both on the facts and law. Right? And you have to tell that story. So you need to master its details. I, even now in the High Court, have these pleadings come before me which just sort of start in the middle somewhere. Okay, the plaintiff, the very second paragraph would be the plaintiff cannot be blamed for breaching the contract because the defendant was not coming on terms with him. So, hang on, what is it? Right? It's like starting from the middle. It's like watching a movie which sort of begins somewhere in the middle. At the same time, you also don't want to write such a long story that the judge gets bored. Remember one thing, your judges don't have time. They are very short on time. The best advocate is the one who can sit back and think that this case, how much effort in writing in an advocacy does this case require? If it requires a 2-page pleading, don't write a 10-page pleading. You'll be wasting your time, you'll be wasting the court's time, you'll be getting lost in unnecessary details. And if it needs 10 pages, think that can you reduce it to 7? This is also an art. Remember, somebody said that it takes me much longer to write a short letter than to write a long letter. Think about it, why did he say so? Because you have to choose the most important detail, the secondary level of detail, and the tertiary level of detail. And that makes you think and that makes you apply your mind, and so that's what we do. So, story. You're telling a story to the judge who opens the case and looks at your plaint and says, has a good flow of, it's very good to go according to the chronology, according to the sequence of as the events happen. At the same time, you want to make sure that you don't put in extraordinary detail. So telling a story, step 2 would be, next slide. Then write it in plain language. This is step number 2. Write it to be understood with ease on first reading. Avoid deliberate verbosity. Using heavy words and difficult words does not at all improve your pleadings, especially if you are not exactly sure of the meaning of that word. Remember, every word has many shades of meaning. And maybe the shade of meaning that you think this word means is not the appropriate meaning in the sentence that you are using it in. So, this is not the place, unless you are a very good writer, you have studied English literature, and you have a really good command on the language, then you can take those liberties. Unfortunately, I'm speaking in English, and we have inherited it. We have to do and write it in English. One of the judges of the Supreme Court, whose quote I had put it on my firm's website, was that the laws of a nation must not be written in a language alien to its citizens. So but this is how it is, this is where we are. At some point in time, we should have moved there, of being able to at least move to our own language. So, anyway, this is a separate topic. So avoid use of deliberate words. If you can use a simple word, go for the simple word. The purpose is for the judge to understand your pleading and not for him to increase his vocabulary. For that he has other avenues. Plain English for lawyers. I'm going to remember just this line, plain English for lawyers. I'll come to it in a bit. Look up for a few precedents of relevant pleadings before drafting. So you have bindras, you have conveyancing books in the libraries. They give you basic pleading formats. If it's a suit for possession, if it's a suit for specific performance, recovery. It helps for you to look at a few precedents. Once you have looked at them and drafted your first one, it will be easy. Then if you are in a chamber with a senior lawyer, before you start drafting, you should ask for a few files of a similar suit and read them and then start drafting. Adhere to the rules of pleading. How many of you know the rules of pleading? Which order of the CPC talks about the rules of pleading?
Order 6.
Well done. So, look at them. They are extremely useful. And so the basic ones are that you should plead facts and not law. Right? Although we are gradually moving to the American style of pleadings where they put in a lot of law in their briefs, we're gradually moving there. But try to not include the law. There's a difference. Including the law means that you start including citations there. Maybe in some case it is so important for you to put it there that you can't avoid it, which would usually happen in constitutional petitions before the High Court, but certainly not in suits. But you can state the legal principle. For instance, you would say that the agreement is not enforceable because there is no consideration for it. So that's a statement of law. You can't go on to say because of such and such. So plead facts, not law, not prolix and not argumentative. Remember, can anyone tell me the difference between grounds and arguments? Think about it. You don't have to tell me now, but if you think about it sufficiently hard, you would hit on a distinction which would be very useful for you in your advocacy.
Sir, in my opinion, grounds are just rational reasons to support your argument. An argument is increasing its significance and telling it in a more convincing way.
Well, that's partly right. That's partly right. Think more about it. In other words, have an understanding in your mind the difference between an argument and a ground in your case. And don't mix them up in your drafting. And don't mix them up even in advocacy. Use both, but have the distinction very clear in your mind. We'll come back to it. And then the prayer clause, very important. This is the distillation that what is it that you want. And many good cases have been lost because the prayer clause wasn't well thought out. So first, and this is a very important point I cannot overemphasize, is first draft the outline and then start writing. Yeah? Like an artist who would first make a sketch and then put the colors in. Just like that. Most of the drafters or lawyers I see, they just sort of start dictating. Maybe somebody who's very experienced, that's fine for them. They know how it will work. But as young lawyers who are starting off, do not start typing or dictating straight away. First that's what I've said, don't start writing at random. Make sure you have the outline ready to the end first. Try headings and subheadings to make the outline. And of course, complete your legal research first. Right. So what would be a good way for a young lawyer to draft is to read the papers, read the books, the legal research, and then think of what the headings and subheadings would be of each paragraph. If you were to put the headings and subheadings, what would they be? If you are able to do that conceptually, then you would have written them, you would automatically see that a structure will emerge. And a structure is very important. A structure will emerge to your writing, and you may then say, I want to move this subtopic under another heading, and I want to move that subheading into this heading. So play around with that, Once you have your outline headings and subheadings ready, then start dictating and writing. Step number 3. Next slide, please. It's still continuing. So, generally aim to target the opponent's positions and not specific people. That makes you more persuasive. It's counterintuitive. I'll tell you what. So, instead of the defendant with ill design wrongly terminated the agreement and is therefore liable to pay damages under section 73, try this. Wrongful termination of agreement by defendant entitles the plaintiff. The plaintiff, the drafting style has come now that everything, almost everything is that mala fide and malintent. Mala fide did it. No. Don't go into mala fide until it is definitely and only a case of mala fide. Look at the legal grounds available. So once we've written it, yes, this was the point. Don't attack the parties if you can avoid it. If you have to, you do. Attack their legal positions. This is what you are there for. You are not going to win a case on the basis of your attack on the other party. You're only going to win a case if you have attacked the legal position of the other party correctly. You don't need to rub the other party into the dust for that. You have to rub the other party's legal position into dust for that. That's the difference. So it takes a few years of diligent observation and conscious effort to acquire a good hand. So it's not money. It's, as I said, it's a lifelong pursuit. Give yourself a year or two, couple of years, and you would automatically practice it, but give yourself at least a couple of years before you can say that I've got the hang of it. Next slide, please. So now, what I call armor plating by the rule of 3. So you have your story, you have written it in a structured manner, but now you need to armor plate it against your opponents. And that's what I call the rule of 3, which is read it thrice, edit it thrice, and revise it thrice. What happens is, and when you are doing this first revision and the second revision, you refer to the documents. Don't just leave it to your imagination. No, look at it again on your first revision, your second revision, and third revision. What will happen is, towards the end, not only the brief will be ready, but so will you. If you've done this exercise, by the third revision of the draft, you will have also mastered your brief, including all the documents that are attached to it. Now the next sentence is, consciously, deliberately practice this each time, cultivate the habit. What happens is that we've done it a couple of times and say, I know it. You would be amazed at what surprises can come up in court when you looked at it once, and on the third or fourth adjournments you're there for the fifth hearing, and you suddenly realize कि भाई इस document में तो वो नहीं लिखा जो मैं समझ रही थी, ये तो कुछ और है. First reading of any evidential document, or even of your own writing, you think it means a certain thing, but it can also mean another thing. And you need to, if it does, you need to counter that while you are preparing your brief, your pleadings. That's when you counter it. The point is, make it a habit. Each time, no matter how simple it and how well you have written it once, read it second time and edit it. Have a pen, edit it. If you work on the computer, edit it. Do it second times and do it the third time also. Maybe the third time you don't really need to make any change in there, but you have to make a R3 habit for yourself. As young lawyers, I would expect that you would make sure that you do that at least for 2 years until it just becomes a habit. Then it will not be a problem. So other points to be conscious of when you are doing your written advocacy, when you are preparing the cases, will your client prefer a settlement? Right. We probably, when we talk about the foreign countries and say 90% cases of theirs settle on the steps of the courtroom. Why does it happen? It happens because a lot of effort goes in their written advocacy. Right? And also because of the robustness of the legal system, of course, that's there. But यहाँ पे general trend क्या है कि people would just make very scanty and basic pleadings and just file them in court and then say कि जब court जाएंगे तो देखेंगे क्या होगा. But when you're meeting your client and you're discussing it with them, then leave open the avenues in your drafting and in your approach for settlement. Remember, only 2 out of 10 litigants would actually want to litigate all the way through. 8 out of 10 out of them are there because of compulsion and they want to get it over and done with and go home and lead their lives. So you need to keep that open. So can the client get what he wants before the suit, during the trial, or only in consequence of a judgment? Consciously think about it. And the last thing is about the practice thing, that your engagement terms, fees, in other words, does it include any settlement negotiations or not? So that is a separate topic. आगे चलिए. So I remember I said plain English for lawyers.
Yes.
Now I just Googled it for you. You would find that there are so many books written on this point. Plain English for lawyers. There are other lots of materials and presentations available on YouTube and others. And there is an appreciation and a trend abroad that there is an alternative to that very jargonic language, jargon, which is in plain English. And it is appreciated now across the board abroad. So take your time and either get a book or look at these presentations and these talks, and you will definitely, I can assure you, you will benefit out of it. Next week. Let's go to oral advocacy. So I want you to, can you all read this?
Yes, sir.
So I will quietly let you read what this says. Okay? Makes sense? This comes from people who have. And the last one, I can vouch for you, having been a judge for 2.5 years now, that I sometimes even now see some of very senior lawyers violating the most elementary principles of advocacy. They hurt their own case as a result. So, what I thought is, next slide. If you see at the top, it is a copyright material from now onwards, and it is only being used for educational purposes. This is a book by Brian Garner, who winning oral argument. Brian Garner is an American author, a very celebrated author who has paid a lot of attention and written books, especially on advocacy skills, preparing appellate briefs, plain English for lawyers. So he has focused a lot on this side. He's been a great advocate for removing the archaic legal terms and bringing in the modern simple terms, alternative terms instead. So we'll slightly change our format of the presentation now. Do we have a working mic? working mic there. So we will start from right end. नहीं यहाँ से अच्छे चले पीछे से शुरू हो जाए यहाँ से इधर से शुरू हो जाए ना यहाँ से पीछे जाता जाएगा. All of you are going to stand up and read one principle, right? And then you're going to hand the mic to the next, to the person sitting next to you. They will stand up and they will read that. Read it thoughtfully and slowly. So there are 5 or 6 topics in this, in oral advocacy. The first one is preparing yourself generally as a public speaker. ठीक है जी? So you stand up and I'll sit down. Right. Shall we will hear you one by one.
Develop a clear, strong, pleasant voice.
Consciously lower the range of your pitch.
What is pitch?
Your voice range. With the voice.
Consciously.
But your speech of comes as a
You know what does this mean? Okay, we'll come back to it. First we'll just go through the entire
Master the proper pronunciation of the terms and proper names, certainly all the ones that might arise in a given opportunity.
Speak with deliberation and force. Avoid speaking too fast, too loudly, or too quietly.
Learn the value of pausing occasionally
At appropriate points.
Express facts in plain words and in chronological order.
Treasure simplicity in presenting your arguments.
Learn to drill straight to the core of a problem. Dwell may knock off summarizing, don't be bogged down in minutes.
Master the arts of allowing ideas to unfold logically in the listener's mind.
It is important to know when to stop as what to say. Not being sure when to stop is a sign of an ill-prepared oration.
Next. Now it is preparing. So the first slide was about speaking, public speaking in general. Now it is preparing for oral argument. So you continue to pass on the mic to the next.
Know your record from cover to the cover and stay written. Know of you can about the judges or discuss their names, their posts, opinions, and whatever do you can possibly learn.
Limit the material you will try to cover.
Know the silent facts that
You missed the one. You missed the one. Number 16.
formulate the words for which your case stands and be willing to show how the rule would lie by
Analogy to other cases.
other cases. No, the silent facts. Say
Be prepared to say this court should rule in a certain way for 3 reasons.
Develop memorable phrasings, even soundbites for the issues in court cases.
Avoid splitting the arguments between two counts.
Know the case you have cited in your brief and the ones you may have cited.
Anticipate questions as best you can.
Practice your document outbound preparing in a
I'll just stop on this one for a while. Practice, we don't have moot courts in Pakistan. It is for young lawyers, it is actually in first or second time if you feel strain. It's stand in front of the mirror. And if you're not afraid or shy of your own image talking back to you, then practice it. What are you going to say to the judge? Remember, your first 30 seconds are the most important before the judge. The first 30 seconds, how you open, that's a separate word. How you open and how you say the first 5 or 6 sentences to the judge are the most important ones. And you need to, it really helps that you can stand in front of the mirror and speak out loud so that you are hearing how does it. Practice what you will. You cannot practice the whole thing. You see, it's not a lecture. It is sort of very interactive. But before going to the court tomorrow on a given case, if you have a brother or sister who is not going to make fun of you, or a friend who's ready to say, sit down, I want to practice something, and starting to hear my part. So do that. It helps.
In the days preceding the arguments, watch another argument or two in the very court where will be argued.
Very important. Right? Very
arrive at court plenty early.
आगे पास मत कर
Do some last minute research to ensure the soundness of your opportunities before enactment.
So that was preparing for oral argument. The day before, a week before, whatever. Now you have the manner of your argument. Right? So let's hear that.
Carry yourself as if you know what you are doing and have done it before.
Yes. Bluff, but bluff with lots of confidence. Right? Even if you have to carry yourself with confidence. You see a lot of judges, lawyers, young lawyers who come who are good, right? But they get nervous and they sort of start mumbling. The first rule that speak in a clear, not overly loud, but a clear voice, they are not able to get. So they don't grasp the purpose of it. This is important.
Make a good first impression before you utter a word. Be presentable, hydrate before it.
Sorry, sir. Slide is out of focus.
Sorry?
How can I focus? I can't.
Have the relevant papers in order and organize them for ready reference.
Unless local customs is to the contrary, always stand when addressing the bench.
When speaking, position yourself, avoid swaying and shifting and other annoying habits, such as gesturing with your pen.
Do you ever like somebody, talking to you as waving your pen? I'm surprised that lawyers do that in court. What it does is that when there is too much gesturing with your hands and all, subconsciously your words stop having the effect that they should have once you start gesturing to the judge. So you would again see that good lawyers rarely use their hands as a gesture, and when they do, They do it at some very critical point. It's a, so don't slouch on the, so an upright posture in the court, confidently standing is very important, like it would in any public speaking context.
Look directly at the judges, not up into his face. Correct with your audience. Connect with your audience.
How come you have it on your mobile?
Sir, अगर eyesight बहुत ज़्यादा weak है.
So how come you have it on your mobile?
Sir, I took a picture at the end.
Ah, okay.
मुझे बता देना था ये idea.
Always cool, calm and temperate, never oblige and never strong. Listen to opposite confer with courtesy and respect without any gesturing and
This is very important. I want another person to read this again. I want another lawyer to read this part, this sentence. The two are very shy, so he's shy of saying, I don't know how he'll stand in court and speak. So you can pass on the mic to the next one. Read this again. 38.
38 point. Always remain cool, calm and temperate. Never agitated and never smug. Listen to the opposing counsel with courtesy and respect without any gesturing or handshake.
Remember, Martin, you would be surprised. That lawyers generally think that if they cut the other lawyer while he's speaking, or speak over him, or speak over the judge, they are doing good advocacy. No, not at all. They are ruining their case. It is better for them to stay quiet when the opposing counsel is speaking something, and even if he is completely wrong. Right? When he is finished, you say to the judge simply this, Sir, now I will speak and tell that he has been wrong or has been telling wrong. Courtesy. Courtesy is very important. Remember, you will tick off a judge who thinks that you may be a great advocate, but you're not courteous. Right? He will give you no marks for being discourteous. And so, no head. And this is again very annoying. It's one of those things that it's very annoying for the judges to, when the counsel is speaking, the other counsel is shaking their heads and saying, no, shaking their heads or gesturing and giving them looks. It detracts. You will have your time. The other counsel will have their time. So be patient. The more courteous, the more graceful you are, the more the judge will appreciate your advocacy.
So is there something that I can really add apart from these points?
In the end, towards the end, we will have a question and answer session. If you want to stay that long.
Never read an argument. Remember that your delivery must sound natural. Memorize only the preferred sequence of your ideas and approach the
lecture
with no more than a few outline points.
Avoid the rhetorical, table-mounting orations of the jury. Go to next.
Be conversational but no management.
Use correct courtroom terminology.
Avoid the first person singular. Be answer with construction on apparent content date. It is our position there and the
use demonstrative aids if they are helpful, but make it easy to see and understand from a distance and person.
So we've done the manner of your argument. What are your manners when you are in court? Now it is the substantive content of your argument. What should be there when you are arguing? Start. Next.
Start with may please the court.
point, try to be present, question for decision, and state your position.
This is something I'm going to stop for a while and tell you once again. Your opener. So there is an opening, there's arguments, and there is closing. The opening is the most important. You like analogy of cricket team, if your openers are out in the first 2 overs, the rest of the team is in a very difficult position. And if your openers have a good inning, take you to 50s, 60s, then the rest can come and play a very good inning. You'll be surprised that very good top advocates, or let's say on the really senior ones, how much effort they put in preparing their opening statements to the first 30 seconds there. So you may need to polish it again and again, because the trick is that in the first minute that you stand before the court, first minute, 60 seconds is a lot of time actually, a lot of time. In the first minute when you're standing before the court, you are able to really put the heart of your case across to the judge, the core of your case. It is, the core of the case is not in the details. Let me give you one example. Which area of law would you want me to give an example? Criminal case. Alright. So, you've done your trial, the evidence is ready, and you prepared now you're doing your closing arguments. One way is to start off by saying PW1 said this and PW2 said this. Another way to say is I would demonstrate to the court that none of the witnesses has been able to support to explain away the contradiction between the ocular testimony and the medical evidence. This is your opening. Instead of coming to it in the end by saying PW1 said this, PW2 said this, PW3 said this, so therefore the ocular account and medical evidence contradicts. No. So your openers, your summary must be there in the first one. Taking an example, for instance, in a suit for specific performance, for instance, your case would be not when your opener, the contract was signed between this and this, and then he did this. Your opener is, I bring this case to the court, or this case concerns the failure of the defendant to make the payment, the balance payment, within the 15 days, which is of the essence of the contract. So that is the case. In fact, this would be, I'm going to give you a trick of the trade, or a secret. That this would be, what would be should be the conclusion in your view in the final judgment of the court. If you were to reduce it down to one line, what would be the conclusion of the court in that judgment? That it should be your opener statement to the judge. That it should be supported by a lawyer. So, work on your openers. Spend more time on it. Summarize it well in your mind. Practice it before so that when you go and say that to the judge, obviously there are going to be 2, 3, 4 points. I've just flashed onto one point. So in the first minute you are able to tell the judge a complete picture of all the key legal points and factual points that on which you will be saying more during arguments. I'll let you. That is, dovetails with the previous one which I just said. Okay, next.
If you're defendant before a full bench, briefly explain the history of the case and the key facts, and start with the controlling law and how the lower courts erred if you are the respondent, whether you must restate the case in the same respect.
If you are before a hot bench, go straight to the most important deep issue.
What's the difference between a cold bench and a hot bench? wants to hazard a guess?
The bench will
We'll say
question too much to the both lawyers.
a court bench is where the judge is known to be cold, relaxed, and has a lot of patience to take a lot of irrelevant stuff from the counsel. A hot bench is which has very little patience with irrelevant points. It just says, please come to the court. So I'm not going to ask you where you rank me, but you. So there are in between also. But if it's a hot bench, you know that. Earlier point, know your judge, know your court. You need to go straight to the question, to the point. With a cold bench, you can take some liberties.
If you present the respondent, don't mistake the facts, but correct any salient errors or omissions in the evidence or petitioner statement.
If you can't read it from that distance, आगे आ जाए.
If the issue involves statutory or contractual language, focus quickly on the words at issue.
Never engage in detailed dissections of the case law. Never bring
triviality
to the court's attention.
Never tell a joke. Avoid contemplative humor. But if you are extraordinarily adept, allow spontaneous, good humor to surface as long as it at no one else expresses.
If the court can't be sure how it will rule on a point, move to another.
Base up your viewpoints, but then say what they are not controlling.
If you have an If you have an unanswerable point that is fatal to your opponent's case, consider closing your argument by suggesting to the court that your opponent should answer it.
So this is now responding to the judge. This is now, you have done the content of your argument. So this is an important area. So responding to the bench.
Responding to the judge, to the bench. Rejoice of questions, except that you may have no chance to speak after then in answer to questions.
If you speak second, never talk at the same time on a judge behind the page. सर इसको zoom कर लें थोड़ा. Zoom.
वैसे मैं वहाँ पीछे पढ़ के आया, मुझे सब नजर आ रहा था वहाँ से. आप गैजेट से इस्तेमाल कम करें, मोबाइल का इस्तेमाल कम करें, तो आप पढ़ के
Answer question directly and the option be the yes or no, or perhaps listen carefully to every question, just as you advise
Second, listen closely to what the judges say.
Reading the answer.
Hypothetical. देखिए बहुत सब होता है बहस में जब चल रहे होते हैं जज कहते हैं नहीं अगर ऐसे हो जाता तो फिर क्या होता तो कई जजेस को लॉयर्स के जवाब देते हैं कि जी ये बात नहीं है केस में ऐसे नहीं बट जज इज ट्राइंग टू अंडरस्टैंड कि अगर ऐसी सिचुएशन हो मैं इसमें आप जो कह रहे हैं मैं वैसा फैसला लिख दूँ तो ऐसी सिचुएशन में क्या होगा तो आपने उसको जवाब देना चाहिए उसको अवॉइड नहीं करना चाहिए और मे भी आप कह सकते हैं कि जी आई डोंट थॉट अबाउट इट उसके बारे में और बात करते हैं
The question directly at answer either yes or no, or perhaps just the two qualifications or no to honor, but the point has some subtitles or subtitles.
After your prompt response, explain your answer more fully if necessary. Never postpone an answer until you have explained something else.
If you don't understand everything,
say some more easily. I must say that today the girls have outperformed the boys.
If you don't know the answer to a question, say so and offer to respond in the next stage or submit a supplemental brief on the point.
after answering, transition back into your argument smoothly. Look for opportunities to use the answer as a cue to your next important point.
To move fast. You have to move fast.
Be sensitive to the judge's body language.
Quickly, children, quickly. We don't have time.
Recognize friendly questions for what they are.
अब बेटा सारे आगे आ जाए ना जो बैक बेंचेस हैं आगे आ जाए.
All right. I don't think if you don't want to, just pass it on to the next one. So that if you don't want to say, pass it on to the next one.
If the judge is downright hostile and express a clear indication that you are wrong, consider an appeal to humility, but you can't be hostile in return. Be firm and confident and frank.
बेटा अगर आपको नजर नहीं आता पहले आगे आ
Stand
जाएगा
firm
ना.
when you need to know what you can and can't concede. Never ask whether you have adequately answered a question and never pose any other substantive question to the bench except to elicit clarification of a judge's question.
Now we are at rebutting, so I'll take it easy for you. On rebutting, you have never waived rebuttal beforehand. take notes for rebuttal, and then refute the more important points with rifle shots. What does rifle shots mean? Difference between buckshot. You know what a buckshot is? And a rifle shot, what's the difference? So rifle shot is precise. It's target with a scope. And a buckshot is where you have many pellets going in all directions. So rebuttal is an important occasion. Then you have to make a guess that my opponent has scored 1 or 2 important or 3 important points. The rest are not that important. So just focus on those 2-3 points and kill it, the strongest points of your opponent. The weaker points, you don't need to spend much time on. So take notes, everybody knows that. Rebut only as necessary and stick to middle points, I just said that. Waive rebuttal if your opponent hasn't scored any points. Actually, this doesn't quite happen in Pakistan, but abroad you would actually see. And in some high-end cases, I have also observed that a smart lawyer knows that the other side hasn't persuaded the judge, stands up and says, I have nothing further to say. So that's what they are saying. Because sometimes, and a smart lawyer would know that to start talking again about that case may open up something new which he doesn't want to expose. Right? So if he thinks that the case is going well, he will avoid rebuttal. And remember the importance of continual improvement. Next slide. Best of luck in your further endeavors. So what will happen is that you have a slide of this presentations. You can download it from their website, इनको बार-बार पढ़िएगा और इसको consciously practice कीजिएगा. One thing, the final thing I would say is that what I have learned and seen in my practice years is that people who are well read are better advocates. So these gadgets that have come in our lives have destroyed the habit of reading. It's gone. But I can assure you that people who have a wide interest in a broad area of reading, who read regularly, will invariably make good advocates. Your language improvement will happen if you read good books. It will not happen by watching YouTube videos and your, texting. Your language ability, your ability to conceptual thinking will only improve by a solid habit of reading. So dedicate half an hour to 1 hour, 45 minutes every day, where you in a book that you enjoy, it must be a book that you enjoy reading, that you sit down with and you spend time with that. So that's it. If you have any questions, I will be able to.
First of all, sir, thank you so much for honoring us with your presence here. It was an immensely informative lecture, and I'm sure that it's going to stay with us till the moment we die, sir. And secondly, sir, everything that you've taught us, sir, so far, it was immensely beautiful, no doubt. But we are practicing in lower courts, and I see everything contrary to what you have taught us so far, sir. What's your take on this, sir? Because in the lower courts,
let's talk in
sir.
Urdu because certain
So,
colleagues of yours here are not.
for example, sir, there was this point of, sir, जैसे कि एक जेस्चरिंग के ऊपर था सर कि पेन नहीं आप जेस्चर कर सकते या आपने अपनी हॉस्टिलिटी नहीं शो करनी. There are senior advocates who are very hostile at times, जो कि बड़े hostile होते हैं towards judges at times. There are several fights happening. फिर interrupt नहीं करना, basic ethics की जो बात है कि while the other जब दूसरा lawyer बोल रहा हूँ तो आपने इंटरप्ट नहीं करना, आपने उनको करने देने कंप्लीट. इसके हर चीज़ कॉन्ट्ररी चल रही है उसमें लोअर कोर्ट में. एंड इफ़ यू आर नॉट लाइक देम देन यू आर एट द लूजर साइड बिकॉज आपको बोलने कोई नहीं देता. एंड देन दे ओवर पावर द मैजिस्ट्रेट्स एंड स्पेसिफिकली इन द मैजिस्ट्रेरियल कोर्ट इट्स लाइक केओस. अगर आप देखिए इतना इन्फ्लक्स ऑफ केसेस है, उसके बाद उनके पास एट टाइम्स भी नहीं होता. देन पुलिस इज ऑल्सो काइंड ऑफ लाइक मिसलीडिंग देम. तो फिर एक बड़ा एक मिलजुल कर एक केओटिक माहौल बना होता है.
आपकी बात बिल्कुल बजा है इस हद तक, लेकिन क्या आप उसी कल्चर को परपेट्रेट करेंगे? जिन सीनियर्स की आप बात कर रहे हैं, अगर उनकी फॉर्मल ट्रेनिंग हुई होती ऑफ देखिए ना यहाँ पे हमारा नहीं है, बट एडवोकेसी इज वन ऑफ द सब्जेक्ट्स जो अगर आप बाहर किसी लॉ स्कूल में पढ़ रहे होंगे तो उसका एक हिस्सा होगा, आपके मूड कोर्स होंगे, आपकी ट्रेनिंग्स होंगी। यहाँ पे आपकी वो ट्रेनिंग नहीं है अभी भी। यू नो दिस जेंटलमैन हैव डन अ वंडरफुल जॉब कि एटलीस्ट आपको कोई तो ओरिएंटेशन मिल रही है 1 घंटे की। पहले तो ये भी नहीं होता, आप बस खुद ही सीखते थे, जिस तरह का आपका सीनियर का स्टाइल होता था आप उसमें चले जाते। बिल्कुल वो लिमिटेशंस हैं, राइट? A gentleman should also know when to throw a punch when the need arises. ये बात नहीं। But the point is, अभी आप यहाँ पे अगर 100 लोग बैठेंगे, अगर वो रिजॉल्व करें कि हमने कम अज कम उस कल्चर को चेंज करना है, we are going to be the agents of change, तो आज से 10 साल बाद आप वो सीनियर्स होंगे जिनको लोग देख रहे हैं। तो आपने ये, जैसे मैंने कहा, ये आपकी एक अपनी चॉइस है। आपने अपने आप को भी देखना है कि मेरे लिए क्या, कौन सा वैल्यू सिस्टम है जो मैं फॉलो करूं। तो बिल्कुल उस हालात में रहे, वहां सारा जब आप ऊंचा बोलना पड़े उस हालात की वजह से बोले, लेकिन उसको अपना स्टाइल ना मजबूरी के तहत करना है तो आपको डजंट आंसर योर क्वेश्चन। और आप खुद देखेंगे, चलो मैजिस्ट्रेट की कोर्ट में नहीं बैठता, जब आप 2, 4, 6 दफा अपीयर होंगे किसी जज के सामने और आप इन प्रिंसिपल्स को एडहियर कर रहे होंगे, कॉन्शियसली अप्लाई कर रहे होंगे, तो वो जजेस अप्रिशिएट करना शुरू कर देंगे इस बात। अगर आपके दूसरे अपोनेंट है, वो शोर मचा रहे हैं, टेबल पे हाथ मार रहे हैं, ऊंचा ऊंचा बोल रहे हैं, आपके जज सबको सिर्फ कह रहे हैं सर मेरा ये स्टाइल ऑफ एडवोकेसी नहीं है, ये अपनी बात खत्म कर लें, मैं आता हूँ तहम्मुल से आपको बताऊंगा मेरा क्या केस क्या है। तो वो जजेस आपको अप्रिशिएट करेंगे, वो आपको नोटिस करेंगे, वो कहेंगे कि यार ये these are gentlemen or the gentle ladies of the bar. That's my answer.
लोअर कोर्ट में भी बहुत सारे कोर्ट्स हैं, बहुत सारे जजेस हैं, वो ऐसा कंडक्ट नहीं होता उनके, बहुत सारी कोर्ट्स हैं आप बात ही क्या, लेकिन बहुत सारे कोर्ट्स में हम जाते हैं, कई होते हैं वो इसी तरह कॉन्टैक्ट करते हैं जैसे हम हाई कोर्ट में हम देख रहे हैं।
आगे बताइए, any other questions? So
thank you sir.
Sir, the advocate I work with my senior just Afzal Khan Shinwari. So I went with him to High Court. It was your court division bench, and along with Justice Mohsin Akhtar Kiani, and he aided you with a fact sheet, like you were writing notes or something. Then he presented you a paper that I have written it briefly for you, the points, and I had made a chart. So that really inspired me because you accepted that. So it means that it was admissible to aid the judge with the bullet points so that it would make your work easier. So that later while you're reviewing the case or making the judgments, so I just had to tell the people or ask you even that we should do that as well to help the judges in remembering the important dates, the important facts.
Very good point. I'm glad you brought it up. देखिए बाहर, and I'm not going to purposely speak in Urdu now, बाहर ये ज़रूरी होता है कि आपके ब्रीफ जब पार्टीज की प्लीडिंग्स वगैरह एक्सचेंज हो जाती हैं और पेशतर इसके कि आप फाइनल बहस करते हैं, आपने स्केलेटन रिटन सबमिशंस देने होते हैं। दे आर कॉल्ड स्केलेटन, लेकिन जिसका मतलब ये होता है कि वही बहुत बातें जो हमने की, कोर बातें जो, और एक क्रोनोलॉजी देनी होती है मैंडेटरी, उसके बगैर आप फाइनल बहस कर ही नहीं सकते। आपको कॉस्ट्स पड़ जाती हैं कोर्ट से कि आपकी क्रोनोलॉजी कितनी है। तो वो आप यहाँ पे डिस्ट्रिक्ट कोर्ट्स में इंट्रोड्यूस करना शुरू कर दें, जजेस रियली अप्रिशिएट करेंगे आपकी बात को, क्योंकि यहाँ पे अनफॉर्चुनेटली आप खुद देखिए जजेस इतने ओवरवर्क्ड हैं और वो इतनी बड़ी फाइल होगी, उसमें से खुद उन्होंने डेट्स ढूंढनी है, खुद उन्होंने सारा कुछ लिखना है। अगर ड्यूरिंग द ट्रायल अगर आप एक अच्छे तरीके से क्रोनोलॉजी बना के, अब आप सारे यंग लोग हैं, यू आर वेरी कंफर्टेबल विद कंप्यूटर्स एंड प्रिंट्स, आपके सीनियर्स नहीं थे, तो आप एक अच्छी क्रोनोलॉजी बनाएं। क्रोनोलॉजी बड़ा इंपॉर्टेंट डॉक्यूमेंट है, सीक्वेंस, और अपने कोशिश करें, मैं तो ऑर्डर में लिखवाता हूँ कि 3 पेज से ज़्यादा ना, 3 पेज के अंदर लिखें। अगर आपके रिटन सबमिशन भी 15 सफ़े के हैं तो आपने जज की हेल्प नहीं की, आपने उसको और मुसीबत में डाल दिया। ये जो कॉन्सेप्ट है कि हम जितना ज़्यादा लिख के जज को देंगे उतना हमारा केस स्ट्रॉन्ग होगा, ये बिल्कुल गलत कॉन्सेप्ट। जितना अच्छे तरीके से केस को समराइज करके एक्यूरेटली रिकॉर्ड को रिफर करते हुए, साइटेशंस का हवाला देते हुए, अगर जज साहब अलग जजमेंट्स मांगते हैं उनको दे दें, लेकिन साइटेशंस का हवाला देते हुए आप जितनी उसको अच्छे तरीके से 3 पेजेस में समराइज करके जज को देंगे, उसके लिए बड़ा वो अप्रिशिएट करेंगे और आप उनका काम आसान करेंगे। और अगर जज आपसे खुश होएगा तो वो आपके केस, आपकी बात को ज़्यादा बहुत तवज्जो देगा। सो इट्स अ गुड पॉइंट। आप अपनी हैबिट बना लें। अगर आपको जजेस नहीं आते, आप मुख्तलिफ केसेस में कहते हैं योर ऑनर में आपके लिए डिस्ट्रिक्ट कोर्ट्स में करें, मैजिस्ट्रेट्स में करें, ये समरी आपके लिए इट विल हेल्प।
Sir, I have a question apart from this advocacy के हवाले से कि I'm from Sindh, तो वहाँ पे जो लॉ फर्म्स हैं तकरीबन जैसे एज अ ट्रेनी वी आर वर्किंग नाउ, तो हम जब एज अ ट्रेनी इस्लामाबाद में कहीं पे भी अप्लाई करते हैं, आई हैव फेस दिस अलॉट, तो वो पे नहीं देते कि आप एज अ ट्रेनी हैं, हम आपको पे नहीं देंगे। उसके बाद व्हेन यू गेट द लाइसेंस, बिकॉज और कोलीग्स भी हैं, उनको भी सर्टेन एरा में पे नहीं मिलती। व्हेन दे आस्क फॉर देयर सीनियर, तो वो कहते हैं कि हमने भी 7-8 साल 10 साल विदाउट पे काम किया है। बट एज वी सी के अदर प्रोफेशन लाइक डॉक्टर एंड एनी अदर प्रोफेशंस, उनको डॉक्टर्स हैं हाउस जॉब में पे मिलना स्टार्ट हो जाती है, या कोई और प्रोफेशंस हैं उनको एवरी प्रोफेशन हैड देयर पे इन देयर ट्रेनिंग प्रोसेस और देयर इंटर्नशिप प्रोसेस, और आफ्टर 1 year they get a sufficient amount. बट वाई इज़ दैट सो कि इस्लामाबाद में ये कल्चर है कि यहाँ पर हर बड़ी लॉ फर्म कहती है वी आर नॉट गोइंग टू गिव यू अ पे। और इसी तरह सिंध बार काउंसिल में जब ये बात उठाई गई, राइज की गई, तो वहाँ पे उन्होंने इम्पोज किया है ये कि कोई भी लॉ फर्म अगर ट्रेनी या इंटर्नी को मिनिमम 25,000 से स्टार्ट है, अगर नहीं देता तो उस लॉ फर्म के खिलाफ वो कंप्लेन कर सकते हैं इन दी बार काउंसिल। सो सर, आप इसके बारे में मतलब क्या एडवाइस करेंगे जो लॉ फर्म्स हैं, क्योंकि ये एक तरह से सर, क्योंकि ये कहते हैं कि इट्स अ प्रोफेशन ऑफ लॉर्ड्स, कि जो जिनका फैमिली बैकग्राउंड अच्छा है, तो ये हम सुनते हैं अपने सीनियर से कि मतलब हम पैसे नहीं देंगे। सर, इस तरह फिर कब तक सरवाइव करेंगे हम? मतलब एक मैं अपनी बात करूं, आई हैव बीन स्टडिंग अ लॉट, BBA देन MBA देन LLB, उसके बाद अब बिल्कुल जीरो से स्टार्ट करने के बाद दे आर सेइंग दैट वी आर नॉट एलिजिबल टू गिव यू अ पे।
ये एक सेपरेट डिस्कशन है, ये ब्रॉडर सेपरेट डिस्कशन है कि लीगल प्रोफेशन के अंदर टू बी एबल टू स्टार्ट पेइंग समवन्स पेटर, अगर आप बाहर की मार्केट स्टडी करें तो आप एज ए ट्रेनी सोलिसिटर जाते हैं तो यू आर पेड, फिर आप उस फर्म के साथ कॉन्ट्रैक्ट भी साइन करते हैं कि मैं इतना साथ के साथ काम नहीं करूँगा। बात ये है बेटा कि हमारी लीगल मार्केट जो एक्चुअली है ना बहुत छोटी है, उसकी जो फाइनेंशियल डेप्थ है वो बहुत कम है। ये और उसकी वजह क्या है कि आपकी इकॉनमी बहुत छोटी है और बहुत कमज़ोर है, और उस इकॉनमी जैसे स्ट्रक्चर हुई हुई है, इट इज़ वेरी हेवीली ड्रिवन बाय द गवर्नमेंट, तो वो इनएफिशिएंट इकॉनमी है। प्राइवेट सेक्टर का उसमें रोल बहुत कम है, जिसकी वजह से मार्केट और आपकी इकॉनमी में बिजनेस एंड कमर्शियल एक्टिविटी बहुत कम है। अब इंग्लैंड में और ऐसे बाहर के मुल्कों में द बिजिएस्ट लॉयर्स वुड नॉट बी क्रिमिनल लॉयर्स, हमारे यहाँ वो बिजिएस्ट लॉयर्स। तो जब आपकी इकोनॉमी इंप्रूव करती है, ट्रांजैक्शंस बढ़ती हैं, कॉन्ट्रैक्ट्स बढ़ते हैं, कमर्शियल एक्टिविटी बढ़ती है, तो उससे रेवेन्यू जनरेट होते हैं और उससे लॉयर्स का रोल बढ़ता है। तो बहुत सारा रोल और भी चीज़ का है। फॉर इंस्टेंस वहाँ पे प्रोफेशन एक्टिव ज़्यादा है। फॉर इंस्टेंस अगर मेरे बस में हो तो मैं तो बार काउंसिल को कहूँगा कि जी आप लेजिस्लेशन पास कराएं कि जिसमें से बाहर हुआ था कि कन्वेंसिंग जितनी लैंड की ट्रांजैक्शन है वो थ्रू ओनली लाइसेंस्ड कन्वेंसेस होगी, जो इन मोस्ट केसेस ट्रेन लॉयर्स, उनका एक 3 महीने का कन्वेंसिंग ट्रेनिंग हो कि आपने 10 में से 6 या 7 सूट्स और स्पेसिफिक परफॉर्मेंस की अपील जो मैं सुन रहा था, अगर आप उनका कॉन्ट्रैक्ट उठा के देखें 10 करोड़ का वो कॉन्ट्रैक्ट होगा और उसमें वो किसी प्रॉपर्टी डीलर ने वो एक सफ़े के ऊपर कॉन्ट्रैक्ट बनाया और फिर उसकी वहाँ पे उन्होंने 50 वहाँ पे पैसे बचाए, उन्होंने जाके किसी वकील को 25, 30, 50 हज़ार फीस नहीं दी कॉन्ट्रैक्ट नेगोशिएट करके ड्राफ्ट करने की, उसके बिल अब वो भुगतने लगे। ये बड़ी डिबेट है, एक बड़ा कॉन्टेक्स्ट है, उसके अंदर कन्वेंशनली और ट्रेडिशनली भी लॉयर्स के लिए पहले फ्यू इयर्स जो है कभी भी उनको कहीं एक्सेप्ट फॉरेन जुरिस्डिक्शन उनको इतनी रेवेन्यू जनरेशन नहीं होती, अपने आप से सपोर्ट करना पड़ता है. लॉट ऑफ पीपल देयरफॉर go into other jobs or go in house, which is fine. प्रोफेशन की नेचर है, इसमें से अगर 10 लोग आएंगे तो उसमें से सिर्फ 2 या 3 वो कामयाब होंगे. Remaining 6 or 7 will not turn out to be very successful lawyers. They would, out of 7, and these are very general numbers of course, they would go into other professions or they would take jobs. So ये it's your staying power, how you can do, how long you can stay in it, how long you can sustain yourself for the first couple of years. But this I can assure you, if you are able to sustain yourself for about 2 years and you put in the hard work and effort that is required and you are there every day, it will pay off very well. It will give its dividends. That's what it is. Ji.
So my question is coming from personal experience. I've noticed some judges in the lower courts getting irritated by lawyers arguing in English. So do you have any recommendation as to which language we should stick to when arguing in court?
Don't argue. If your judge is signaling to you by his behavior, his body language, and that he is not comfortable with you arguing in English, don't. Why do you want to annoy your judge? You're not going to win your case.
But is there a recommended language that we should stick to?
देखिए, it is some of you will be good in English, some of you are not good in English. As I said earlier, that you should not let your excellence in English dominate the other qualities and expertise that you require to be a successful lawyer. Just speaking good English doesn't make you a successful lawyer. At the same time, वो जो कि जिनकी English अच्छी नहीं है, they should not let it dishearten them because they can practice their Urdu so well. उसमें improve करें. आप उर्दू में भी अगर वो फारिग है, तो फिर तो उनको नहीं ऐसे होना चाहिए.
आपको जो प्राइमरी क्वेश्चन ये है कि अगर आप इंग्लिश में आर्ग्यू नहीं कर सकती हैं, उर्दू में आर्ग्यू नहीं कर सकती हैं आप, तो ये आपका पहला पॉइंट है कि आपको इस तरीका है कि आप जज को बताइए कि जी मेरी उर्दू बहुत अच्छी नहीं है, तो मैं आपको कोशिश करूँगा इंग्लिश में. ये मैं क्वेश्चन
My cause of concern is actually the fact that in some courtrooms it's completely acceptable. In fact, the judges actually appreciate your eloquence. But then in some courtrooms, I have observed judges actually going as far as saying, please pardon me, but this is something that I've observed someone actually say कि जज साहब आपको बहुत अंग्रेजी आ रही है, आप बाहर जाके अंग्रेजी निकालते रह गए. So how are we supposed to?
You are supposed to switch to Urdu.
Okay.
Because that simply means that the judge is saying or telling you कि जी मेरी अंग्रेजी इतनी अच्छी नहीं है. अगर आप इसमें कोई देखिए ना, हमारी जुबान नहीं है अंग्रेजी. अब कुछ लोगों की उनके बैकग्राउंड की वजह से, उनकी तालीम की वजह से, वो बाहर से पढ़ के आ गया, कोई और है, उनकी अंग्रेजी तो बहुत अच्छी है. इसका मतलब ये तो नहीं है कि जो बाकी लोग हैं वो डिसएडवांटेज है. मेरे नज़दीक एज ए जज मैं आपको बता सकता हूँ, असल बात इतनी अंग्रेजी तो सबको ही आती है कि वो छोटी मोटी मतलब एक बात जज के सामने कर सके. और अगर उतनी भी नहीं आती कि वो कॉन्फिडेंटली अंग्रेजी के कोई जुमले नहीं बोल सकते, तो उनको प्रैक्टिस करनी चाहिए, उनको कोई कोर्सेज देने चाहिए, उनको इसकी प्रैक्टिस करनी चाहिए. But answering your question, it's very simple. Just if you cannot make your judge uncomfortable. It means that the judge is not comfortable with his own English skills, and therefore he is feeling uncomfortable with you. Make him comfortable. Switch to Urdu. जैसे उन्होंने कहा, if you can't speak Urdu, tell him कि I'm sorry, I have to because I don't know. That's what it is.
But ऐसा कुछ mandatory तो नहीं है कि आपको एक specific language को ही you have to stick to that.
देखिए, English क्यों preferred as court language? Because your judgments are in English and your law is in English, so it becomes easy for the conversation and the judgments to be in English. Until we are able to switch to pleadings, and writing of our judgments in Urdu. Justice Jawad Khwaja ne likha bhi tha, I was a great supporter of that, but it kind of disappeared.
उर्दू की प्रिंटिंग बहुत मुश्किल है एज कम्पेयर टू आप अगर पढ़े ना तो बहुत ही मुश्किल है।
अच्छा, उसमें भी मैं अब इनकी बात पे सेकंड करूंगा कि उसमें भी देखें वो जो लैंग्वेज है वो पुरानी आर्केइक लैंग्वेज है, राइट? सो दी वहाँ पे भी ज़रूरत है कि आप प्लेन उर्दू की तरफ जाना शुरू कर दें, तो वहाँ बहुत ज़रूरत है।
अपील अगेंस्ट द जजमेंट मींस अपील बराज़गी हुक्म मोरखा फलां, ये इसका ट्रांसलेशन है। अपील अगेंस्ट द जजमेंट। थैंक यू जी, थैंक यू सो मच।